Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in United States v. Texas. In this case, the court considered these issues. 1. Do the state plaintiffs have Article 3 standing to challenge the Department of Homeland Security's guidelines for the enforcement of civil immigration law? 2. Do the guidelines violate the Administrative Procedure Act? 3. Does 8 U.S.C. Section 1252 F.1 prevent the entry of an order to hold unlawful and set aside the guidelines under 5 U.S.C. Section 706(2)? The case was decided on June 23, 2023. The Supreme Court held that Texas and Louisiana lack Article 3 standing to challenge immigration enforcement guidelines promulgated by the Secretary of Homeland Security that prioritize the arrest and removal of certain non-citizens from the United States. Justice Brett Kavanaugh authored the majority opinion of the court. For a plaintiff to establish standing, they must show that they have suffered a real specific injury that was caused by the defendant and that the court can remedy. While the district court had concluded that the states would suffer an injury in the form of additional costs due to the arrest policy in question, the Supreme Court pointed out that the injury also has to be legally and judicially cognizable. In other words, that it should be a type of dispute that courts have traditionally been involved in resolving. The states failed to point to any precedent or historical practice that supported their claim to have standing in this particular issue. Second, the court acknowledged that there are good reasons for federal courts to avoid these types of lawsuits, one of which is the executive branch's discretion in deciding whom to arrest or prosecute, which falls under its constitutional Article 2 powers. Additionally, the courts generally lack the standards to judge the appropriateness of such enforcement decisions, which can be influenced by various factors like resource constraints and public safety needs. This conclusion does not mean that federal courts can never handle cases involving the executive branch's decisions about arrests or prosecutions. Indeed, certain circumstances might warrant a different standing analysis. For instance, if there are claims of selective prosecution based on discrimination, or if Congress has explicitly made certain injuries legally recognizable. Justice Neil Gorsuch authored an opinion concurring in the judgment, in which Justices Clarence Thomas and Amy Coney Barrett joined, arguing that the states lack standing not because of the cognizable injury aspect of standing, but because of the redressability requirement. Justice Barrett authored an opinion concurring in the judgment, in which Justice Gorsuch joined, also arguing that the case should be resolved on redressability grounds. Justice Samuel Alito authored a dissenting opinion, arguing that Texas does have standing. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kavanaugh delivered the opinion of the court. In 2021, after President Biden took office, the Department of Homeland Security issued new guidelines for immigration enforcement. The guidelines prioritize the arrest and removal from the United States of non-citizens who are suspected terrorists or dangerous criminals, or who have unlawfully entered the country only recently. For example, Texas and Louisiana sued the Department of Homeland Security. According to those states, the department's new guidelines violate federal statutes that purportedly require the department to arrest more criminal non-citizens pending their removal. The states essentially want the federal judiciary to order the executive branch to alter its arrest policy so as to make more arrests. But this court has long held that a citizen lacks standing to contest the policies of the prosecuting authority when he himself is neither prosecuted nor threatened with prosecution. Consistent with that fundamental Article 3 principle, we conclude that the states lack Article 3 standing to bring this suit. In 2021, Secretary of Homeland Security Mayorkas promulgated new guidelines for the enforcement of civil immigration law. The guidelines prioritize the arrest and removal from the United States of non-citizens who are suspected terrorists or dangerous criminals, or who have unlawfully entered the country only recently. For example, Texas and Louisiana sued the Department of Homeland Security, as well as other federal officials and agencies. According to those states, the guidelines contravene two federal statutes that purportedly require the department to arrest more criminal non-citizens pending their removal. First, the states contend that for certain non-citizens, such as those who are removable due to a state criminal conviction, Section 1226C of Title 8 says that the department shall arrest those non-citizens and take them into custody when they are released from state prison. Second, Section 1231A(2), as the states see it, provides that the department shall arrest and detain certain non-citizens for 90 days after entry of a final order of removal. In the state's view, the department's failure to comply with those statutory mandates imposes costs on the states. The states assert, for example, that they must continue to incarcerate or supply social services such as health care and education to non-citizens who should be, but are not being, arrested by the federal government. The U.S. District Court for the Southern District of Texas found that the states would incur costs as a result of the department's guidelines. Based on those costs, the District Court determined that the states have standing. On the merits, the District Court ruled that the guidelines are unlawful and vacated the guidelines. The U.S. Court of Appeals for the Fifth Circuit declined to stay the district court's judgment. This court granted certiorari before judgment. Article 3 of the Constitution confines the federal judicial power to cases and controversies. Under Article 3, a case or controversy can exist only if a plaintiff has standing to sue, a bedrock constitutional requirement that this court has applied to all manner of important disputes. As this court's precedents amply demonstrate, Article 3 standing is not merely a troublesome hurdle to be overcome if possible so as to reach the merits of a lawsuit which a party desires to have adjudicated. It is a part of the basic charter promulgated by the framers of the Constitution at Philadelphia in 1787. The principle of Article 3 standing is built on a single basic idea, the idea of separation of powers. Standing doctrine helps safeguard the judiciary's proper and properly limited role in our constitutional system. By ensuring that a plaintiff has standing to sue, federal courts prevent the judicial process from being used to usurp the powers of the political branches. According to Texas and Louisiana, the arrest policy spelled out, the Department of Homeland Security's 2021 guidelines does not comply with the statutory arrest mandates in Section 1226C and Section 1231A-2. The states want the federal judiciary to order the department to alter its arrest policy so that the department arrests more non-citizens. The threshold question is whether the states have standing under Article 3 to maintain this suit. The answer is no. To establish standing, a plaintiff must show an injury, in fact caused by the defendant, and redressable by a court order. The district court found that the states would incur additional costs, because the federal government is not arresting more non-citizens. Monetary costs are of course an injury, but this court has also stressed that the alleged injury must be legally and judicially cognizable. That requires, among other things, that the dispute is traditionally thought to be capable of resolution through the judicial process. In other words, that the asserted injury is traditionally redressable in federal court. In adhering to that core principle, the court has examined history and tradition, among other things, as a meaningful guide to the types of cases that Article 3 empowers federal courts to consider. The states have not cited any precedent, history, or tradition of courts ordering the executive branch to change its arrest or prosecution policies so that the executive branch makes more arrests or initiates more prosecutions. On the contrary, this court has previously ruled that a plaintiff lacks standing to bring such a suit. The leading precedent is Linda R.S. v. Richard D. The plaintiff in that case contested a state's policy of declining to prosecute certain child support violations. This court decided that the plaintiff lacked standing to challenge the state's policy, reasoning that in American jurisprudence at least, a party lacks a judicially cognizable interest in the prosecution of another. The court concluded that a citizen lacks standing to contest the policies of the prosecuting authority when he himself is neither prosecuted nor threatened with prosecution. The court's Article 3 holding in Linda R.S. applies to challenges to the executive branch's exercise of enforcement discretion over whether to arrest or prosecute. And importantly, that Article 3 standing principle remains the law today. The states have pointed to no case or historical practice holding otherwise. A telling indication of the severe constitutional problem with the state's assertion of standing to bring this lawsuit is the lack of historical precedent supporting it. In short, this court's precedents and long-standing historical practice establish that the state suit here is not the kind redressable by a federal court. Several good reasons explain why, as Linda R.S. held, federal courts have not traditionally entertained lawsuits of this kind. To begin with, when the executive branch elects not to arrest or prosecute, it does not exercise coercive power over an individual's liberty or property, and thus does not infringe upon interests that courts often are called upon to protect. And for standing purposes, the absence of coercive power over the plaintiff makes a difference. When a plaintiff's asserted injury arises from the government's allegedly unlawful regulation, or lack of regulation, of someone else, much more is needed to establish standing. Moreover, lawsuits alleging that the executive branch has made an insufficient number of arrests or brought an insufficient number of prosecutions run up against the executive's Article 2 authority to enforce federal law. Article 2 of the Constitution assigns the executive power to the President, and provides that the President shall take care that the laws be faithfully executed. Under Article 2, the executive branch possesses authority to decide how to prioritize and how aggressively to pursue legal actions against defendants who violate the law. The executive branch, not the judiciary, makes arrests and prosecutes offenses on behalf of the United States. That principle of enforcement discretion over arrests and prosecutions extends to the immigration context, where the court has stressed that the executive's enforcement discretion implicates not only normal domestic law enforcement priorities, but also foreign policy objectives. In line with those principles, this court has declared that the executive branch also retains discretion over whether to remove a non-citizen from the United States. In addition to the Article 2 problems raised by judicial review of the executive branch's arrest and prosecution policies, courts generally lack meaningful standards for assessing the propriety of enforcement choices in this area. After all, the executive branch must prioritize its enforcement efforts. That is because the executive branch, invariably lacks the resources to arrest and prosecute every violator of every law, and 2, must constantly react and adjust to the ever-shifting public safety and public welfare needs of the American people. This case illustrates the point. As the district court found, the executive branch does not possess the resources necessary to arrest or remove all of the non-citizens covered by Section 1226C and Section 1231A2. That reality is not an anomaly, it is a constant. For the last 27 years since Section 1226C and Section 1231A2 were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests. In light of inevitable resource constraints and regularly changing public safety and public welfare needs, the executive branch must balance many factors when devising arrest and prosecution policies. That complicated balancing process in turn leaves courts without meaningful standards for assessing those policies. Therefore, in both Article 3 cases and Administrative Procedure Act cases, this court has consistently recognized that federal courts are generally not the proper forum for resolving claims that the executive branch should make more arrests or bring more prosecutions. All of those considerations help explain why federal courts have not traditionally entertained lawsuits of this kind. By concluding that Texas and Louisiana lack standing here, we abide by and reinforce the proper role of the federal judiciary under Article 3. The state's novel standing argument, if accepted, would entail expansive judicial direction of the department's arrest policies. If the court greenlighted this suit, we could anticipate complaints in future years about alleged executive branch under enforcement of any similarly worded laws, whether they be drug laws, gun laws, obstruction of justice laws, or the like. We decline to start the federal judiciary down that uncharted path. Our constitutional system of separation of powers contemplates a more restricted role for Article 3 courts. In holding that Texas and Louisiana lack standing, we do not suggest that federal courts may never entertain cases involving the executive branch's alleged failure to make more arrests or bring more prosecutions. First, the court has adjudicated selective prosecution claims under the Equal Protection Clause. In those cases, however, a party typically seeks to prevent his or her own prosecution, not to mandate additional prosecutions against other possible defendants. Second, as the Solicitor General points out, the standing analysis might differ when Congress elevates de facto injuries to the status of legally cognizable injuries redressable by a federal court. For example, Congress might, specifically authorize suits against the executive branch by a defined set of plaintiffs who have suffered concrete harms from executive under enforcement and, 2, specifically authorize the judiciary to enter appropriate orders requiring additional arrests or prosecutions by the executive branch. Here, however, the relevant statutes do not supply such specific authorization. The statutes, even under the state's own reading, simply say that the department shall arrest certain non-citizens. Given the deep-rooted nature of law enforcement discretion, a purported statutory arrest mandate, without more, does not entitle any particular plaintiff to enforce that mandate in federal court. For an arrest mandate to be enforceable in federal court, we would need at least a stronger indication from Congress that judicial review of enforcement discretion is appropriate. For example, specific authorization for particular plaintiffs to sue, and for federal courts to order more arrests or prosecutions by the executive. We do not take a position on whether such a statute would suffice for Article 3 purposes. Our only point is that no such statute is present in this case. Third, the standing calculus might change if the executive branch wholly abandoned its statutory responsibilities to make arrests or bring prosecutions. Under the Administrative Procedure Act, a plaintiff, arguably, could obtain review of agency non-enforcement if an agency has consciously and expressly adopted a general policy that is so extreme as to amount to an abdication of its statutory responsibilities. So too, an extreme case of non-enforcement arguably could exceed the bounds of enforcement discretion and support Article 3 standing. But the states have not advanced a heckler-style abdication argument in this case, or argued that the executive has entirely ceased enforcing the relevant statutes. Therefore, we do not analyze the standing ramifications of such a hypothetical scenario. Fourth, a challenge to an executive branch policy that involves both the executive branch's arrest or prosecution priorities and the executive branch's provision of legal benefits or legal status could lead to a different standing analysis. That is because the challenged policy might implicate more than simply the executive's traditional enforcement discretion. Again, we need not resolve the Article 3 consequences of such a policy. Fifth, Policies governing the continued detention of non-citizens who have already been arrested arguably might raise a different standing question than arrest or prosecution policies. But this case does not concern a detention policy, so we do not address the issue here. The discrete standing question raised by this case rarely arises because federal statutes that purport to require the executive branch to make arrests or bring prosecutions are rare, not surprisingly, given the executive's Article II authority to enforce federal law and the deeply rooted history of enforcement discretion in American law. Indeed, the states cite no similarly worded federal laws. This case therefore involves both a highly unusual provision of federal law and a highly unusual lawsuit. To be clear, our Article III decision today should in no way be read to suggest or imply that the executive possesses some freestanding or general constitutional authority to disregard statutes requiring or prohibiting executive action. Moreover, the federal judiciary of course routinely and appropriately decides justiciable cases involving statutory requirements or prohibitions on the executive. This case is categorically different. However, because it implicates only one discrete aspect of the executive power, namely, the executive branch's traditional discretion over whether to take enforcement actions against violators of federal law, and this case raises only the narrow Article III standing question of whether the federal judiciary may in effect order the executive branch to take enforcement actions against violators of federal law, here, by making more arrests. Under this court's Article III precedents and the historical practice, the answer is no. It bears emphasis that the question of whether the federal courts have jurisdiction under Article III is distinct from the question of whether the executive branch is complying with the relevant statutes, here Section 1226C and Section 1231A, 2. In other words, the question of reviewability is different from the question of legality. We take no position on whether the executive branch here is complying with its legal obligations under Section 1226C and Section 1231A, 2. We hold only that the federal courts are not the proper forum to resolve this dispute. On that point, even though the federal courts lack Article III jurisdiction over this suit, other forums remain open for examining the executive branch's arrest policies. For example, Congress possesses an array of tools to analyze and influence those policies: oversight, appropriations, the legislative process, and Senate confirmations, to name a few. And through elections, American voters can both influence executive branch policies and hold elected officials to account for enforcement decisions. In any event, those are political checks for the political process. We do not opine on whether any such actions are appropriate in this instance. The court's standing decision today is narrow and simply maintains the long-standing jurisprudential status quo. The court's decision does not alter the balance of powers between Congress and the executive, or change the federal judiciary's traditional role in separation of powers cases. In sum, the states have brought an extraordinarily unusual lawsuit. They want a federal court to order the executive branch to alter its arrest policies so as to make more arrests. Federal courts have not traditionally entertained that kind of lawsuit. Indeed, the states cite no precedent for a lawsuit like this. The states lack Article III standing because this court's precedents and the historical experience preclude the state's attempt to litigate this dispute at this time and in this form. And because the states lack Article III standing, the district court did not have jurisdiction. We reverse the judgment of the district court. It is so ordered. Justice Gorsuch, with whom Justice Thomas and Justice Barrett join, concurring in the judgment. The court holds that Texas and Louisiana lack Article III standing to challenge the Department of Homeland Security's guidelines for the enforcement of civil immigration law. I agree, but respectfully, I diagnose the jurisdictional defect differently. The problem here is redressability. Article III vests federal courts with the power to decide cases and controversies. Standing doctrine honors the limitations inherent in this assignment by ensuring judges attend to actual harms rather than abstract grievances. If individuals and groups could invoke the authority of a federal court to forbid what they dislike, for no more reason than they dislike it, we would risk exceeding the judiciary's limited constitutional mandate and infringing on powers committed to other branches of government. To establish standing to sue in federal court, a plaintiff must show that it has suffered a concrete and particularized injury, one that is both traceable to the defendant and redressable by a court order. If a plaintiff fails at any step, the court cannot reach the merits of the dispute. This is true whether the plaintiff is a private person or a state. After all, standing doctrine derives from Article III, and nothing in that provision suggests a state may have standing when a similarly situated private party does not. The court holds that Texas and Louisiana lack standing to challenge the guidelines because a party lacks a judicially cognizable interest in the prosecution of another. To be sure, the district court found that the guidelines have led to an increase in the number of aliens with criminal convictions and final orders of removal who are released into the states. The district court also found that, thanks to this development, the states have spent, and continue to spend, more money on law enforcement, incarceration, and social services. Still, the court insists, several good reasons explain why these harms are insufficient to afford the states standing to challenge the guidelines. I confess to having questions about each of the reasons the court offers. Start with its observation that the states have not pointed to any historical practice of courts ordering the executive branch to change its arrest or prosecution policies. The court is right, of course, that history and tradition offer a meaningful guide to the types of cases that Article 3 empowers federal courts to consider. But, again, the district court found that the guidelines impose significant costs on the states. The court today does not set aside this finding as clearly erroneous. Nor does anyone dispute that even $1 worth of harm is traditionally enough to qualify as concrete injury under Article 3. Indeed, this court has allowed other states to challenge other executive branch policies that indirectly cause them monetary harms. So why are these states now forbidden from doing the same? Next, the court contends that, when the executive branch elects not to arrest or prosecute, it does not exercise coercive power over an individual's liberty or property. Here again, in principle, I agree. But if an exercise of coercive power matters so much to the Article 3 standing inquiry, how to explain decisions like Massachusetts v. EPA? There, the court held that Massachusetts had standing to challenge the federal government's decision not to regulate greenhouse gas emissions from new motor vehicles. And what could be less coercive than a decision not to regulate? In Massachusetts v. EPA, the court chose to overlook this difficulty in part because it thought the state's claim of standing deserved special solicitude. I have doubts about that move. Before Massachusetts v. EPA, the notion that states enjoy relaxed standing rules had no basis in our jurisprudence. Nor has special solicitude played a meaningful role in this court's decisions in the years since. Even so, it's hard not to wonder why the court says nothing about special solicitude in this case. And it's hard not to think, too, that lower courts should just leave that idea on the shelf in future ones. Finally, the court points to the fact that Article 2 vests in the president considerable enforcement discretion, so much so that courts generally lack meaningful standards for assessing the propriety of the executive branch's enforcement choices. But almost as soon as the court announces this general rule, it adds a caveat, stressing that this case concerns only arrest and prosecution policies. It's a curious qualification. Article 2 does not have an arrest and prosecution clause. It endows the president with the executive power and charges him with taking care that federal laws are faithfully executed. These provisions give the president a measure of discretion over the enforcement of all federal laws, not just those that can lead to arrest and prosecution. So if the court means what it says about Article 2, can it mean what it says about the narrowness of its holding? There's another curious qualification in the court's opinion too. The standing calculus might change, we are told, if the executive branch wholly abandoned its statutory responsibilities to make arrests or bring prosecutions. But the court declines to say more than that because the states have not advanced such an argument. Is that true though? The states have pleaded a claim under the Take Care Clause. Is that not an abdication argument? Did they fail to plead it properly? Or is the court simply ignoring it? As I see it, the jurisdictional problem the states face in this case isn't the lack of a judicially cognizable interest or injury. The states prove that the guidelines increase the number of aliens with criminal convictions and final orders of removal released into the states. They also prove that, as a result, they spend more money on everything from law enforcement to healthcare. The problem the states face concerns something else altogether: a lack of redressability. To establish redressability, a plaintiff must show from the outset of its suit that its injuries are capable of being remedied by a favorable decision. Ordinarily, to remedy harms like those the states demonstrated in this suit, they would seek an injunction. The injunction would direct federal officials to detain aliens consistent with what the states say the immigration laws demand. But even assuming an injunction like that would redress the state's injuries, that form of relief is not available to them. It is not available because of 8 U.S.C. Section 1252 F.1. There, Congress provided that no court, other than the Supreme Court, shall have jurisdiction or authority to enjoin or restrain the operation of certain immigration laws, including the very laws the states seek to have enforced in this case. If there were any doubt about how to construe this command, we resolved it in a prior case. In that case, we held that Section 1252 F.1 prohibits lower courts from ordering federal officials to take or to refrain from taking actions to enforce, implement, or otherwise carry out the specified statutory provisions. Put simply, the remedy that would ordinarily have the best chance of redressing the state's harms is a forbidden one in this case. The district court thought it could sidestep Section 1252 F.1. Instead of issuing an injunction, it purported to vacate the guidelines pursuant to Section 7062 of the Administrative Procedure Act, APA, 5 U.S.C. Section 7062. Vacatur, as the district court understood it, is a distinct form of relief that operates directly on agency action, depriving it of legal force or effect. And vacatur, the district court reasoned, does not offend Section 1252 F.1, because it does not entail an order directing any federal official to do anything. The states embrace this line of argument before us. It's a clever workaround, but it doesn't succeed. Start with perhaps the simplest reason. Assume for the moment the district court was right that Section 1252(f)(1) does not bar vacatur orders and that Section 7062 authorizes courts to issue them. Even so, a vacatur order still does nothing to redress the state's injuries. The guidelines merely advise federal officials about how to exercise their prosecutorial discretion when it comes to deciding which aliens to prioritize for arrest and removal. A judicial decree rendering the guidelines a nullity does nothing to change the fact that federal officials possess the same underlying prosecutorial discretion. Nor does such a decree require federal officials to change how they exercise that discretion in the guidelines' absence. It's a point even the states have acknowledged. Faced with that difficulty, the states offer this reply. As a practical matter, they say, we can expect federal officials to alter their arrest and prosecution priorities in light of a judicial opinion reasoning that the guidelines are unlawful. But this doesn't work either. Whatever a court may say in an opinion does no more to compel federal officials to change how they exercise their prosecutorial discretion than an order vacating the guidelines. Nor do we measure redressability by asking whether a court's legal reasoning may inspire or shame others into acting differently. We measure redressability by asking whether a court's judgment will remedy the plaintiff's harms. As this court recently put it, it is a federal court's judgment, not its opinion, that remedies an injury. Thus it is the judgment, not the opinion, that demonstrates redressability. If the rule were otherwise, and courts could simply assume that everyone will honor the legal rationales that underlie their decrees, then redressability would always exist. Perhaps sensing they have run into yet another roadblock, the states try one last way around it. Fleetingly, they direct us to the parenthetical in Section 1252(f)(1), other than the Supreme Court. That language, they say, allows this court to invoke the All Writs Act, 28 U.S.C. Section 1651, to fashion its own injunction. And the possibility that this court might award them relief, the states suggest, makes their injuries redressable after all. It's an argument that yields more questions than answers. The parenthetical the states cite is a curious provision, one that does not appear to have an analog elsewhere in the United States Code. Even assuming it permits this court to award an injunction when a case comes to us on review, it does not obviously solve the state's redressability problem. Normally, after all, a plaintiff must establish redressability from the outset of the suit. Not only that, a plaintiff must show a favorable decision is likely to provide effectual relief. When the states filed this suit, however, the possibility that it might find its way to this court was speculative at best. Nor is that the only complication. Ordinarily, to win an injunction from any court, a party must satisfy several factors. The states relegate any mention of these factors to a short, formulaic paragraph tacked onto the end of their brief. Worse, the only injunction they seek is one barring implementation and enforcement of the guidelines, essentially an injunction imitating a vacatur order. And, as we have seen, an order like that would leave officials with their prosecutorial discretion intact. So, even if this court were to take the unusual step of issuing and superintending its own injunction, giving the states the very order they seek is hardly sure to redress the injuries they assert. Beyond these redressability problems may lie still another. Recall the essential premise on which the district court proceeded, that the APA empowers courts to vacate agency action. The federal government vigorously disputes this premise, arguing that the law does not contemplate this form of relief. The reasons the government offers are plenty and serious enough to warrant careful consideration. Traditionally, when a federal court finds a remedy merited, it provides party-specific relief, directing the defendant to take or not take some action relative to the plaintiff. If the court's remedial order affects non-parties, it does so only incidentally. This tracks the founding era understanding that courts render a judgment or decree upon the rights of the litigants. More, also ensures that federal courts respect the limits of their Article III authority to decide cases and controversies, and avoid trenching on the power of the elected branches to shape legal rights and duties more broadly. After all, the judicial power is the power to decide cases for parties, not questions for everyone. Despite these foundational principles, in recent years a number of lower courts have asserted the authority to issue decrees that purport to define the rights and duties of sometimes millions of people who are not parties before them. 3 years ago, I reflected on the rise of the universal injunction, and raised questions about its consistency with the separation of powers and our precedents. I observed too that the routine issuance of universal injunctions has proven unworkable, sowing chaos for litigants, the government, courts, and all those affected by these sometimes conflicting decrees. Matters have not improved with time. Universal injunctions continue to intrude on powers reserved for the elected branches. They continue to deprive other lower courts of the chance to weigh in on important questions before this court has to decide them. They continue to encourage parties to engage in forum shopping and circumvent rules governing class-wide relief. Recent events have highlighted another problem too. Sometimes the government may effectively submit to a universal decree running against it in order to avoid the usual and important requirement under the APA that a regulation originally promulgated using notice and comment may only be repealed through notice and comment. It is a strategy that amounts to little more than rulemaking by collective acquiescence. Today's case presents a variation on the theme. The district court ordered wholesale vacatur of the guidelines, rendering them inoperable with respect to any person anywhere. As authority for its course, the district court cited Section 7062 of the APA. That provision does not say anything about vacating agency action, wholesale or otherwise. Instead, it authorizes a reviewing court to set aside agency action. Still, from those two words alone, the district court thought the power to nullify the guidelines with respect to anyone, anywhere surely follows. Color me skeptical. If the Congress that unanimously passed the APA in 1946 meant to overthrow their bedrock practice of case-by-case judgments with respect to the parties in each case, and vest courts with a new and far-reaching remedial power, it surely chose an obscure way to do it. At the very least, it is worth a closer look. Begin with the words set aside in isolation. If they might suggest to some a power to vacate agency action in the sense of rendering it null and void, just as naturally they might mean something else altogether. They might simply describe what a court usually does when it finds a federal or state statute unconstitutional, or a state law preempted by a federal one. Routinely, a court will disregard offensive provisions like these, and proceed to decide the parties' dispute without respect to them. For example, Justice Frankfurter observed that we are to set aside the judgment of those whose duty it is to legislate only if the Constitution requires it. Justice Frankfurter hardly meant to suggest the court had the power to erase statutes from the books. Instead, he used the phrase to mean that a court should disregard, refuse to apply, an unconstitutional law. It is a usage that was common at the time of the APA's adoption, and that remains so today. There are many reasons to think set-aside uses disregard rather than vacate. For one thing, at the time of the APA's adoption, conventional wisdom regarded agency rules as quasi-legislative in nature, and federal courts have never enjoyed the power to vacate legislation. Instead, they possess little more than the negative power to disregard an unconstitutional enactment. Reading set aside to mean disregard ensures parallel judicial treatment of statutes and rules. For another thing, the term set aside appears in a section titled Scope of Review, a title it has borne since the law's enactment. And ordinarily, when we think about the scope of a court's review, we do not think about the remedies the court may authorize after reaching its judgment on the merits. Instead, we think about the court's decisional process leading up to that judgment. Understanding set aside as a command to disregard an unlawful rule in the decisional process fits perfectly within this design. Understanding the phrase as authorizing a remedy does not. What follows appears to confirm the point. The statute begins by providing that, to the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning and applicability of the terms of an agency action. Exactly as expected, we find an instruction about the decisional process, one requiring the court to apply de novo review on questions of law, as it considers the parties' arguments in the course of reaching its judgment. Nothing here speaks to remedies. The remaining statutory language is more of the same. It goes on to instruct that the reviewing court shall hold unlawful and set aside agency action, findings and conclusions found to be, among other things, arbitrary, capricious, contrary to constitutional right, in excess of statutory authority, or unsupported by substantial evidence. Looking at the provision as a whole, rather than focusing on two words in isolation, we see further evidence that it governs a court's scope of review or decisional process. The statute tells judges to resolve the cases that come to them without regard to deficient agency action, findings, or conclusions, an instruction entirely consistent with the usual negative power of courts to disregard that which is unlawful. Other details are telling too. Consider the latter part of the directive to set aside agency action, findings, and conclusions. The APA defines agency action to include the whole or a part of an agency rule, order, license, sanction, relief, or the equivalent or denial thereof, or failure to act. A court can disregard any of those things. But what would it even mean to say a court must render null and void an agency's failure to act? Notice too the language about findings. Often judges disregard factual findings unsupported by record evidence, and resolve the case at hand without respect to them. None of that means we may pretend to rewrite history and scrub any trace of faulty findings from the record. Consider as well the larger statutory context. It restricts judicial review to persons who have suffered legal wrong because of agency action, or been adversely affected or aggrieved by agency action. The provision also instructs that any mandatory or injunctive decree shall specify the federal officer or officers personally responsible for compliance. Here it seems, Congress nodded to traditional standing rules and remedial principles. Yet under the district court's reading, we must suppose Congress proceeded just a few paragraphs later to plow right through those rules and empower a single judge to award a novel form of relief affecting parties and non-parties alike. Then there is another section. That is where the APA most clearly discusses remedies. It authorizes aggrieved persons to bring any applicable form of legal action, including actions for declaratory judgments or writs of prohibitory or mandatory injunction or habeas corpus. Conspicuously missing from the list is vacatur. And what exactly would a form of legal action seeking vacatur look like anyway? Would it be a creature called a writ of vacatur? Nobody knows or bothers to tell us. Nor is it apparent why Congress would have listed most remedies only to bury another, and arguably the most powerful one, in a later section addressed to the scope of review. The district court's reading of set aside invites still other anomalies. It governs all proceedings under the APA. Any interpretation of set aside therefore must make sense in the context of an enforcement proceeding, an action for a declaratory judgment, a suit for an injunction, or habeas. This poses a problem for the district court's interpretation, for no one thinks a court adjudicating a declaratory action or a habeas petition vacates agency action along the way. The anomaly dissipates, however, if we read set aside as instructing courts about when they must disregard agency action in the process of deciding a case. Imagine what else it would mean if set aside really did authorize vacatur. Ordinary joinder and class action procedures would become essentially irrelevant in administrative litigation. Why bother jumping through those hoops when a single plaintiff can secure a remedy that rules the world? Surely, too, it is odd that leading scholars who wrote extensively about the APA after its adoption apparently never noticed this supposed remedy. These are not people who would have missed such a major development in their field. As always, there are arguments on the other side of the ledger, and the states tee up several. They first reply that Section 706(2) must allow vacatur of agency action because the APA models judicial review of agency action on appellate review of judgments, and appellate courts sometimes vacate judgments. But just because? Congress may sometimes refer to collateral judicial review of executive action as an appeal does not make it an appeal akin to that taken from the district court to the Court of Appeals. Nor does any of that tell us in which respects the APA models judicial review of agency action on appellate review of lower court judgments. According to one scholar, the salient similarities between appellate review and judicial review of agency action concern the standards of review. In both types of proceedings, a reviewing court engages in a more rigorous review of legal questions and a more deferential review of factual findings. None of that has to do with remedies. Once again, it concerns a court's scope of review or decisional process. The states next invoke Section 706(1) and Section 705. The former provides that courts shall compel agency action unlawfully withheld or unreasonably delayed. The latter says courts may issue all necessary and appropriate process to postpone the effective date of an agency action, or to preserve status or rights pending conclusion of the review proceedings. The states insist that it would be illogical for the APA to authorize these remedies but not vacatur. Is it so clear, though, that Section 706(1) and Section 705 authorize remedies? Section 706(1) does seem to contemplate a remedy, but it's one Section 703 mentions mandatory injunctions. So, Section 706(1) might not authorize a remedy as much as confirm the availability of a traditional remedy to address agency inaction. The same could be said about Section 705. It might just confirm courts' authority to issue traditional equitable relief pending judicial review. The states also direct us to scholarship that in turn purports to identify a few instances of federal courts setting aside agency action in the years leading up to the APA. It is not obvious, however, that these few cases stand for so much. In two of them, this court upheld the agency action in question, and thus had no occasion to opine on appropriate relief. In a third case, the plaintiff sought to enjoin enforcement of an order of the Federal Communications Commission. That is a claim for traditional equitable relief, and indeed, the court held that the complaint stated a cause of action in equity and remanded for further proceedings. A fourth case, involving an order of the Interstate Commerce Commission, seems of a piece. There, a district court held the commission's order invalid and restrained enforcement of it. This court affirmed. True, this court described the case as an appeal from a decree, setting aside the commission's order. But the fact that the lower court had only restrained enforcement of the order goes to show that set aside did not then, and does not now necessarily translate to vacate. At the end of the day, the states fall back on other lower court decisions. For more than 30 years, they say, vacatur has been the ordinary result when the D.C. Circuit determines that agency regulations are unlawful. Doubtless, to the extent those decisions are carefully reasoned, they merit respectful consideration. But, equally, they do not bind us. In raising questions about the district court's claim that Section 706(2) authorizes vacatur of agency action, I do not pretend that the matter is open and shut. Thoughtful arguments and scholarship exist on both sides of the debate, nor do I mean to equate vacatur of agency action with universal injunctions. Despite some similarities, courts can at least arguably trace their authority to order vacatur to language in a statute, and practice in some lower courts. But the questions here are serious ones, and given the volume of litigation under the APA, this court will have to address them sooner or later. Until then, we would greatly benefit from the considered views of our lower court colleagues. Suppose my doubts about vacatur are unfounded. Suppose the APA really does authorize both traditional forms of equitable relief, in Section 703, and a more expansive equitable power to vacate agency action, in Section 706. Even if that were true, a district court should think twice, and perhaps twice again, before granting such sweeping relief. After all, this court has long instructed that equitable relief must be limited to the inadequacy that produced the injury in fact. Any remedy a judge authorizes must not be more burdensome to the defendant than necessary to redress the complaining parties, and faithful application of those principles suggests that an extraordinary remedy like vacatur would demand truly extraordinary circumstances to justify it. The temptations a single district judge may face when invited to vacate agency rules are obvious. Often, plaintiffs argue that everyone deserves to benefit from their effort to litigate the case and the court's effort to decide it. Judges may think efficiency and uniformity favor the broadest possible relief, but there are serious countervailing considerations. As with universal injunctions, vacatur can stymie the orderly review of important questions, lead to forum shopping, render meaningless rules about joinder and class actions, and facilitate efforts to evade the APA's normal rulemaking processes. Vacatur can also sweep up non-parties who may not wish to receive the benefit of the court's decision. Exactly, that happened here. Dozens of states, counties, and cities tell us they did not seek and do not want the benefit of the district court's vacatur order in this case. More importantly still, universal relief, whether by way of injunction or vacatur, strains our separation of powers. It exaggerates the role of the judiciary in our constitutional order, allowing individual judges to act more like a legislature by decreeing the rights and duties of people nationwide. This court has warned that few exercises of the judicial power are more likely to undermine public confidence in the neutrality and integrity of the judiciary than one which casts courts in the role of a council of revision, conferring on themselves the power to invalidate laws at the behest of anyone who disagrees with them. At a minimum then, district courts must carefully consider all these things before doling out universal relief. And courts of appeals must do their part too, asking whether party-specific relief can adequately protect the plaintiff's interests. If so, an appellate court should not hesitate to hold that broader relief is an abuse of discretion. In our system of government, federal courts play an important but limited role by resolving cases and controversies. Standing doctrine honors this limitation at the front end of every lawsuit. It preserves a forum for plaintiffs seeking relief for concrete and personal harms, while filtering out those with generalized grievances that belong to a legislature to address. Traditional remedial rules do similar work at the back end of a case. They ensure successful plaintiffs obtain meaningful relief, but they also restrain courts from altering rights and obligations more broadly in ways that would interfere with the power reserved to the people's elected representatives. In this case, standing and remedies intersect. The states lack standing because federal courts do not have authority to redress their injuries. Section 1252 F1 denies the states any coercive relief. A vacatur order under Section 706(2) supplies them no effectual relief, and such an order itself may not even be legally permissible. The states urge us to look past these problems, but I do not see how we might. The Constitution affords federal courts considerable power, but it does not establish government by lawsuit. Justice Barrett, with whom Justice Gorsuch joins, concurring in the judgment. I agree with the court that the states lack standing to challenge the federal government's guidelines for the enforcement of immigration law, but I reached that conclusion for a different reason. The states failed to show that the district court could order effective relief. Justice Gorsuch ably explains why that is so. And because redressability is an essential element of Article 3 standing, the district court did not have jurisdiction. The court charts a different path. In its view, this case can be resolved based on what it calls the fundamental Article 3 principle that a citizen lacks standing to contest the policies of the prosecuting authority when he himself is neither prosecuted nor threatened with prosecution. In other words, the court says, the states have not asserted a judicially cognizable interest in this case. Respectfully, I would not take this route. To begin with, I am skeptical that Linda R.S. suffices to resolve this dispute. First, the court reads that decision too broadly. Consider the facts. The mother of an illegitimate child sued in federal court, apparently seeking an injunction running against the district attorney, forbidding him from declining prosecution of the child's father for failure to pay child support. She objected, on equal protection grounds, to the state's view that fathers of illegitimate children were not within the ambit of the relevant child neglect statute. we agreed that the plaintiff suffered an injury stemming from the failure of her child's father to contribute support payments. But if the plaintiff were granted the requested relief, it would result only in the jailing of the child's father. Needless to say, the prospect that prosecution would lead to child support payments could, at best, be termed only speculative. For this reason, we held that the plaintiff lacked standing. Only then, after resolving the standing question on redressability grounds, did we add that a private citizen lacks a judicially cognizable interest in the prosecution or non-prosecution of another. In short, we denied standing in Linda R.S. because it was speculative that the plaintiff's requested relief would redress her asserted injury, not because she failed to allege one. Viewed properly, Linda R.S. simply represents a specific application of the general principle that when the plaintiff is not himself the object of the government action or inaction he challenges, standing is not precluded, but it is ordinarily substantially more difficult to establish given the causation and redressability issues that may arise. That is true for the states here. I see little reason to seize on the case's bonus discussion of whether a private citizen has a judicially cognizable interest in the prosecution or non-prosecution of another, to establish a broad rule of Article 3 standing. Second, even granting the broad principle the court takes from Linda R.S., I doubt that it applies with full force in this case. Unlike the plaintiff in Linda R.S., the states do not seek the prosecution of any particular individual, or even any particular class of individuals. In fact, they disclaim any interest in the prosecution or non-prosecution of non-citizens. They acknowledge that a detention obligation only applies until the government makes a decision whether or not to prosecute, and they readily concede that if the government decides not to prosecute, any detention obligation imposed by Section 1226(c)(1) immediately ends. The states make similar concessions with respect to Section 1231(a)(2). They maintain, for example, that Section 1231(a)(2) applies only where the United States has used its prosecutorial discretion to bring a notice to appear, to prosecute that all the way to a final order of removal. But if the government for any reason chooses to discontinue proceedings, the alleged detention obligation does not attach. The upshot is that the states do not dispute that the government can prosecute whomever it wants. They seek, instead, the temporary detention of certain non-citizens during elective removal proceedings of uncertain duration, and the states desire to remove the guidelines' influence on the government's admittedly broad discretion to enforce immigration law meaningfully differs from the Linda R.S. plaintiff's desire to channel prosecutorial discretion toward a particular target. Given all of this, I would not treat Linda R.S. as the leading precedent for resolving this case. In my view, the court is striking new ground rather than applying settled principles. In addition to its reliance on Linda R.S., the court offers several reasons why federal courts have not traditionally entertained lawsuits of this kind. I am skeptical that these reasons are rooted in Article 3 standing doctrine. Take, for example, the court's discussion of Castle Rock v. Gonzalez. There, we reason that given the deep-rooted nature of law enforcement discretion, a true mandate of police action would require some stronger indication from the legislature than, for example, the bare use of the word shall in a statutory directive. The court today concludes that no such statute is present in this case. But Castle Rock is not a case about Article 3 standing. It addressed whether an individual who has obtained a state law restraining order has a constitutionally protected property interest under the 14th Amendment in having the police enforce the restraining order when they have probable cause to believe it has been violated. I see no reason to opine on Castle Rock's application here, especially given that the parties, correctly, treat Castle Rock as relevant to the merits of their statutory claims rather than to the states standing to bring them. The court also invokes the executive's Article 2 authority to enforce federal law. I question whether the president's duty to take care that the laws be faithfully executed is relevant to the standing analysis. While it is possible that Article 2 imposes justiciability limits on federal courts, it is not clear to me why any such limit should be expressed through Article 3's definition of a cognizable injury. Moreover, the court works the same magic on the take care clause that it does on Castle Rock. It takes an issue that entered the case on the merits and transforms it into one about standing. The court leans, too, on principles set forth in Heckler v. Cheney. But, again, Heckler was not about standing. It addressed a different question: the extent to which a decision of an administrative agency to exercise its discretion not to undertake certain enforcement actions is subject to judicial review under the Administrative Procedure Act. Heckler held that an agency's decision not to take enforcement action should be presumed immune from judicial review under the APA, but such a decision is only presumptively unreviewable. The presumption may be rebutted where the substantive statute has provided guidelines for the agency to follow in exercising its enforcement powers. Whatever Heckler's relevance to cases like this one, it does not establish a principle of Article 3 standing, and elevating it to the status of a constitutional rule would transform it from a case about statutory provisions that Congress is free to amend, to one about a constitutional principle that lies beyond Congress's domain. Although the court notes that Heckler involved the APA, Its conflation of heckler with standing doctrine is likely to cause confusion. The court weaves together multiple doctrinal strands to create a rule that is not only novel, but also in tension with other decisions. In my view, this case should be resolved on the familiar ground that it must be likely, as opposed to merely speculative, that any injury will be redressed by a favorable decision. I respectfully concur only in the judgment. Justice Alito, dissenting. The court holds Texas lacks standing to challenge a federal policy that inflicts substantial harm on the state and its residents by releasing illegal aliens with criminal convictions for serious crimes. To reach this conclusion, the court brushes aside a major precedent that directly controls the standing question, refuses to apply our established test for standing, disregards factual findings made by the district court after a trial, and holds that the only limit on the power of a president to disobey a law like the important provision at issue is Congress's power to employ the weapons of inter-branch warfare, withholding funds, impeachment, and removal, etc. I would not blaze this unfortunate trail. I would simply apply settled law, which leads ineluctably to the conclusion that Texas has standing. This court has long applied a three-part test to determine whether a plaintiff has standing to sue. Under that test, a plaintiff must plead and ultimately prove that it has been subjected to, or imminently faces an injury that is 1. Concrete and particularized, 2. Fairly traceable to the challenged action, and 3. Likely to be redressed by a favorable decision. Under that familiar test, Texas clearly has standing to bring this suit. Nevertheless, the United States, the defendant in this case, has urged us to put this framework aside and adopt a striking new rule. At argument, Solicitor General was asked whether it is the position of the United States that the Constitution does not allow any party to challenge a president's decision not to enforce laws he does not like. What would happen, the Solicitor General was asked, if a president chose not to enforce the environmental laws or the labor laws? Would the Constitution bar an injured party from bringing suit? She responded that under this court's precedent, the framers intended political checks in that circumstance, and if an administration did something that extreme and said they were not going to enforce the law at all, then the president would be held to account by the voters, and Congress has tools at its disposal as well. Thus, according to the United States, even if a party clearly meets our three-part test for Article 3 standing, the Constitution bars that party from challenging a president's decision not to enforce the law. Congress may wield what the Solicitor General described as political tools, which presumably means such things as withholding funds, refusing to confirm presidential nominees, and impeachment and removal, but otherwise Congress and the American people must simply wait until the president's term in office expires. The court, at least for now, does not fully embrace this radical theory and instead holds only that, with some small and equivocal limitations, no party may challenge the executive's arrest and prosecution policies. But the court provides no principled explanation for drawing a line at this point, raising the concern that the court's only reason for framing its rule as it does is that no more is needed to dispose of this case. In future cases, presidential power may be extended even further. That disturbing possibility is bolstered by the court's refusal to reject the government's broader argument. As I will explain, nothing in our precedents even remotely supports this grossly inflated conception of executive power, which seriously infringes the legislative powers that the Constitution grants to Congress. At issue here is Congress's authority to control immigration, and this court has repeatedly emphasized that over no conceivable subject is the legislative power of Congress more complete than it is over the admission of aliens. In the exercise of that power, Congress passed and President Clinton signed a law that commands the detention and removal of aliens who have been convicted of certain particularly dangerous crimes. The Secretary of Homeland Security, however, has instructed his agents to disobey this legislative command and instead follow a different policy that is more to his liking. And the court now says that no party injured by this policy is allowed to challenge it in court. That holding not only violates the Constitution's allocation of authority among the three branches of the federal government, it also undermines federalism. This year, court has held that the federal government's authority in the field of immigration severely restricts the ability of states to enact laws or follow practices that address harms resulting from illegal immigration. If states are also barred from bringing suit even when they satisfy our established test for Article 3 standing, they are powerless to defend their vital interests. If a president fails or refuses to enforce the immigration laws, the states must simply bear the consequences. That interpretation of executive authority and Article 3's case or controversy requirement is deeply and dangerously flawed. The court's opinion omits much that is necessary to understand the significance of its decision, and I therefore begin by summarizing the relevant statutory provisions, the challenged Department of Homeland Security, DHS action and the district court's findings of fact regarding the injury faced by the state of Texas as the result of what DHS has done. The relevant statutory provisions have figured in several prior decisions, and in those cases, we have recounted how they came to be enacted and have clearly described what they require. These provisions were part of the Illegal Immigration Reform and Immigration Responsibility Act of 1996, FIRA, which was adopted against a backdrop of wholesale failure by the Immigration and Naturalization Service to deal with increasing rates of criminal activity by aliens. Congress concluded that a central cause of that failure was the Attorney General's broad discretion to conduct individualized bond hearings and to release criminal aliens from custody during their removal proceedings. To remedy this problem, Congress subtracted some of that discretion when it comes to the arrest and release of criminal aliens. Two such limits are important here. First, the government is directed to take into custody any alien inadmissible or deportable on certain criminal or terrorist grounds when the alien is released from criminal custody, including when such an alien is released on parole, supervised release, or probation. Second, there is a categorical detention mandate. The government is required to detain an alien during the removal period, which often begins either when an order of removal becomes administratively final, or when an alien is released from detention or confinement not arising from the immigration process. This requirement is reinforced by the direction that under no circumstance during the removal period shall the government release an alien found inadmissible or deportable under almost any of the grounds relevant under the law. The government is also commanded to remove the alien within the removal period. All of our recent decisions interpreting these provisions confirm that, for covered aliens, shall means shall, it does not mean may. Until quite recently, that was the government's understanding as well. Actions taken by Congress when FIRA was enacted underscore this conclusion, because the provisions described above left the executive with no discretion to refrain from arresting and detaining covered aliens. Even during the time immediately after FIRA's enactment, when the executive was still expanding its capacities to enforce the new law, Congress passed transition rules that delayed the onset of the Secretary's obligation to begin making arrests as soon as covered aliens were released from criminal custody. If the executive had possessed the discretion to decline to enforce the new mandates in light of resource constraints, those transition rules would have been entirely superfluous. Despite this clear text and background, the majority now claims that the President's enforcement discretion survived these mandates, but there is no basis for that conclusion. Certainly, it is not supported by the cases it cites. They either underscore the general rule that the executive possesses enforcement discretion, or pair that general rule with the observation that the states cannot limit the government's discretion in pursuing removal. Nothing in those decisions is inconsistent with Congress's power to displace executive discretion, and the fact that 5 presidential administrations sometimes neglected the mandates is likewise irrelevant. As I have stressed before, the executive cannot acquire authority forbidden by law through a process akin to adverse possession, and that is true even if the adverse possession is bipartisan. The events that gave rise to this case began on January 20, 2021, when the acting Secretary of DHS issued a memorandum with enforcement priorities for the detention and removal of aliens found to be in this country illegally. This memorandum prioritized 1. Aliens whose apprehension implicated national security, 2. Aliens not present before November 1, 2020, and 3. Aliens due to be released from criminal confinement who had both been convicted of an aggravated felony and were determined to pose a threat to public safety. This prioritization was inconsistent with the Section 1226C arrest mandate, which extends to all aliens convicted of any crime within a long list of statutory categories. In February, Immigrations and Customs Enforcement, ICE, an arm of DHS, issued a second memorandum that slightly modified the earlier priorities, and stated that pre-approval would generally be required for enforcement actions against persons outside these priority groups. This memorandum was also inconsistent with the relevant statutes. After some litigation regarding these two memoranda, a new DHS secretary issued a final memorandum instructing that even aliens in priority groups need not necessarily be apprehended and removed. Rather, the final memorandum directed DHS personnel to consider non-statutory aggravating and mitigating factors in deciding whether to detain an alien. It further stated that DHS personnel should not rely on the fact of a qualifying conviction when exercising prosecutorial discretion. Thus, the final memorandum did not simply permit deviations from the statutory mandates. It flatly contradicted those mandates by stating that qualifying convictions were insufficient grounds for initiating arrest, detention, and removal. Texas and Louisiana challenged this final memorandum in federal court under the Administrative Procedure Act, APA. After a 2-day bench trial, the district court found in favor of the states and made detailed findings of fact that bear on the issue of standing. Much of the district court's analysis of that issue focused on the final memorandum's effect on the detainer system, and it is therefore important to understand how that system works in relation to the relevant statutory provisions. When an alien in state custody for a criminal offense is identified as falling within a category of aliens whose apprehension and detention is required by sections 1226A and C, the government should lodge a detainer with the state so that the government can take the alien into custody when he or she is released by the state. Then, when an alien is about to be released, a cooperative state will notify DHS so that it can be ready to assume its obligation under sections 1226A and C to take the alien into federal custody. When that occurs, the state is spared the burdens it would have to bear if the alien, after release, had been placed under state law on probation, parole, or supervised release. But if DHS rescinds a detainer before such an alien is released, or never lodges a detainer in the first place, those burdens fall on the state. After reviewing the parties' evidence, the district court found that in the first month after the substantive policy change brought about by the January 2021 DHS memorandum, ICE had rescinded 141 detainers in Texas. 95 of the criminal aliens whose detainers were rescinded were then released on a form of state supervision. 17 of them went on to violate their terms of supervision, and 4 committed new crimes. The court then examined what had taken place during just the time since the final memorandum became effective, and found that because of the final memorandum, ICE had continued to rescind detainers placed on criminal aliens in Texas's custody, and the court identified 15 specific cases in which this had occurred. Rejecting the government's claim that these dropped detainers were necessary in light of limited resources, the court found that the government persistently underutilized existing detention facilities during the relevant time, and that the average daily detained population in April 2022 was less than 40% of the 3-year high in August 2019. Based on these findings of fact and historical data, the district court identified 4 categories of costs that Texas had suffered and would continue to bear as a result of the relevant DHS actions. First, the court calculated the dollars and cents cost that Texas had to bear in order to supervise criminal aliens who were released in violation of the statutory requirements. Second, it noted the costs associated with criminal recidivism. Third, it found that some juvenile offenders who are not detained by ICE because of the final memorandum will attend Texas public schools, and at least one juvenile due to be released will do so. Fourth, it concluded that the hundreds of millions of dollars that Texas annually spends on health care for illegal aliens would increase when some criminal aliens not detained because of the final memorandum make use of those services. Concluding that these costs establish Texas's injury for standing purposes, the district court went on to hold that the final memorandum was contrary to law, and that Texas had therefore established a violation of the Administrative Procedure Act. As I will explain, it is a common practice for courts in APA cases to set aside an improper final agency action, and that is what the district court did here. It vacated the final memorandum pending further action by DHS, but it declined to issue injunctive or declaratory relief. The government asked the Court of Appeals to stay the district court's order vacating the final memorandum, but that court refused to do so and observed that the government had not come close to showing clear error in the district court's factual findings on the injuries that Texas had already incurred and would continue to incur because of the final memorandum. Before I address the court's inexplicable break from our ordinary standing analysis, I will first explain why Texas easily met its burden to show a concrete, particularized injury that is traceable to the final memorandum and redressable by the courts. Injury, in fact. The district court's factual findings, which must be accepted unless clearly erroneous, quantified the cost of criminal supervision of aliens who should have been held in DHS custody, and also identified other burdens that Texas had borne, and would continue to bear going forward. These findings suffice to establish a concrete injury that was specific to Texas. Traceability? The district court found that each category of cost would increase because of the final memorandum, rather than decisions that DHS personnel would make irrespective of the directions that memorandum contains. The majority does not hold, and in my judgment could not plausibly hold, that these findings are clearly erroneous. Instead, it observes only that a state's claim for standing can become more attenuated when based on the indirect effects of federal policies on state revenues or state spending. But while it is certainly true that indirect injuries may be harder to prove, an indirect financial injury that is proved at trial supports standing. And that is what happened here. As Justice Gorsuch notes, just a few years ago, we found in a very important case that a state had standing based in part on indirect financial injury. There is no justification for a conflicting holding here. In any event, many of the costs in this case are not indirect. When the federal government refuses or fails to comply with the statutory requirements as to criminal aliens, the direct result in many cases is that the state must continue its supervision. As noted, District Court made specific findings about the financial cost that Texas incurred as a result of DHS's failure to assume custody of aliens covered by the statutory requirements, and the costs that a state must bear when it is required to assume the supervision of criminal aliens who should be kept in federal custody are not only financial. Criminal aliens whom DHS unlawfully refuses to detain may be placed on state probation, parole, or supervised release, and some will commit new crimes and end up in a state jail or prison. Probation, parole, and corrections officers are engaged in dangerous work that can put their lives on the line. Redressability? A court order that forecloses reliance on the memorandum would likely redress the state's injuries. If, as the district court found, DHS personnel rescind detainers because of the final memorandum, then vacating that memorandum would likely lead to those detainers remaining in place. While the majority does not contest redressability, Justice Gorsuch's concurrence does, citing two reasons. But the first is contrary to precedent, and the second should not be addressed in this case. The first asserted reason is based on the inability of the lower courts to issue a broad injunction forbidding enforcement of the final memorandum. In this case, the district court did not issue injunctive relief. Instead, it vacated the final memorandum, and Justice Gorsuch argues that this relief did not redress Texas's injuries because it does not require federal officials to change how they exercise their prosecutorial discretion in the final memorandum's guidelines absence. There are two serious problems with this argument. First, the provision bars injunctive relief by courts other than the Supreme Court. As a result, redress in the form of an injunction can be awarded by this court. According to the court's decision last term, our authority to grant such relief left no doubt as to our jurisdiction, even if the provision precluded the lower courts from setting aside an administrative action under the APA. We have not been asked to revisit this holding, and I would not do so here. Second, even if the previous decision could be distinguished and no injunctive relief can be awarded by any court, setting aside the final memorandum satisfies the redressability requirement. Our decision in a previous case settles that question. There, the court held that a declaratory judgment regarding the lawfulness of executive branch action satisfied redressability, because it was substantially likely that the president and other executive officials would abide by an authoritative interpretation of the law, even though they would not be directly bound by such a determination. Here, we need not speculate about how DHS officers respond to vacatur of the final memorandum, because the district court found that the DHS personnel responsible for detainers were rescinding them because of the final memorandum. This point was effectively conceded by the government's application for an emergency stay pending our decision in this case. The government argued that the final memorandum was needed to guide prosecutorial discretion, and if the district court's order were ineffectual, that would not be true. For these reasons, the harm resulting from the final memorandum is redressed by setting aside the final memorandum. As to the concurrence's second argument, that the APA's set-aside language may not permit vacatur, the concurrence acknowledges that this would be a sea change in administrative law as currently practiced in the lower courts. We did not grant review on this very consequential question, and I would not reach out to decide it in a case in which the previous decision resolves the issue of redressability. To be clear, I would be less troubled than I am today if Justice Gorsuch's concurrence had commanded a majority. At least then, Congress would be free to amend the provision. But the majority reaches out and redefines our understanding of the constitutional limits on otherwise available lawsuits. It is to this misunderstanding that I now turn. The majority adopts the remarkable rule that injuries from an executive decision not to arrest or prosecute, even in a civil case, are generally not cognizable. Its reasoning has three failings. First, it fails to engage with contrary precedent that is squarely on point. Second, it lacks support in the cases on which it relies. Third, the exceptions, or possible exceptions, that it notes do nothing to allay concern about the majority's break from our established test for Article 3 standing. I address each of these problems in turn. Prior to today's decision, it was established law that plaintiffs who suffer a traditional injury resulting from an agency decision not to proceed with an enforcement action have Article 3 standing. The obvious parallel to the case before us is Massachusetts v. EPA, which has been called the most important environmental law case ever decided by the court. In that prior case, Massachusetts challenged the Environmental Protection Agency's failure to use its civil enforcement powers to regulate greenhouse gas emissions that allegedly injured the Commonwealth. Massachusetts argued that it was harmed because the accumulation of greenhouse gases would lead to higher temperatures. Higher temperatures would cause the oceans to rise, and rising sea levels would cause the Commonwealth to lose some of its dry land. The court noted that Massachusetts had a quasi-sovereign interest in avoiding the loss of territory, and that our federalist system had stripped the Commonwealth of certain sovereign prerogatives that it could have otherwise employed to defend its interests. Proclaiming that Massachusetts' standing claim was entitled to special solicitude, the court held that the Commonwealth had standing. The reasoning in that case applies with at least equal force in the case at hand. In Massachusetts v. EPA, the court suggested that allowing Massachusetts to protect its sovereign interests through litigation compensated for its inability to protect those interests by the means that would have been available had it not entered the Union. In the present case, Texas's entry into the Union stripped it of the power that it undoubtedly enjoyed as a sovereign nation to police its borders and regulate the entry of aliens. The Constitution and federal immigration laws have taken away most of that power, but the statutory provisions at issue in this case afford the state at least some protection, in particular by preventing the state and its residents from bearing the costs, financial and non-financial, inflicted by the release of certain dangerous criminal aliens. Our law on standing should not deprive the state of even that modest protection. We should not treat Texas less favorably than Massachusetts, and even if we do not view Texas's standing argument with any special solicitude, we should at least refrain from treating it with special hostility by failing to apply our standard test for Article 3 standing. Despite the clear parallel with this case, and the state's heavy reliance on Massachusetts throughout their briefing, the majority can only spare a passing footnote for that important precedent. It first declines to say Massachusetts was correctly decided, and references the disagreements that some may have with that decision. But it then concludes that Massachusetts does not control since the decision itself refers to key differences between a denial of a petition for rulemaking and an agency's decision not to initiate an enforcement action, with the latter not ordinarily subject to judicial review. The problem with this argument is that the portion of Massachusetts to which the footnote refers deals not with its key Article 3 holding, but with the scope of review that is ordinarily available under the statutory scheme. Importantly, Massachusetts frames its statement about declining enforcement as restating the rule from earlier decisions, and as the court acknowledges when it invokes that decision directly, that decision is not about standing. It is about the interpretation of the statutory exception to review for actions committed to agency discretion by law, and even in that context, it expressly contemplates that any presumption of discretion to withhold enforcement can be rebutted by an express statutory limitation of discretion, which is exactly what we have here. So rather than answering questions about this case, the majority's footnote on Massachusetts raises more questions about Massachusetts itself. Most importantly, has this monumental decision been quietly interred? Massachusetts v. EPA is not the only relevant precedent that the court brushes aside. It is well established that this court has an independent obligation to assure that standing exists, regardless of whether it is challenged by any of the parties. Yet in case after case, with that obligation in mind, we have not questioned the standing of states that brought suit under the APA to compel civil enforcement. In Little Sisters of the Poor Saints, Peter and Paul Home v. Pennsylvania, two states sued under the APA, and sought to compel the Department of Health and Human Services to cease exercising regulatory enforcement discretion that exempted certain religious employers from compliance with a contraceptive coverage mandate. The issue of the state's standing was discussed at length in the decision below, and in this court, no justice suggested that the Constitution foreclosed standing simply because the states were complaining of the executive branch's enforcement choices regarding third parties. Just last term in Biden v. Texas, two states argued that their spending on the issuance of driver's licenses and the provision of health care for illegal immigrants sufficed to establish Article 3 standing, and thus enabled them to sue to compel enforcement of a detain or return mandate. The Court of Appeals held that the states had standing, and the majority in this court, despite extended engagement with other jurisdictional questions, never hinted that Article 3 precluded the state's suit. If the new rule adopted by the court in this case is sound, these decisions and others like them were all just wasted ink. I understand that what we have called drive-by jurisdictional rulings are not precedents, but the court should not use a practice of selective silence to accept or reject prominently presented standing arguments on inconsistent grounds. Examination of the precedents the majority invokes only underscores the deficiencies in its analysis. The majority says that the leading precedent supporting its holding is Linda R.S. v. Richard D., but, as Justice Barrett notes, this court has already definitively explained that the suit to compel prosecution in Linda R.S. was rejected because of the unlikelihood that the relief requested would redress appellant's claimed injury. But sure tan single CF? Cite to Linda R.S. provides the court no help. Sure tan only rejected, quite reasonably, any standalone cognizable interest in procuring enforcement of the immigration laws by a party who lacked any personal interest. And it did so, not as part of a standing analysis, but as part of its explanation for rejecting two employers' attempt to assert that seeking to have employees deported as retaliation for union activity was an aspect of their First Amendment right to petition the government for a redress of grievances. After these two inapposite precedents, the majority's authority gets even weaker. I agree with Justice Barrett that neither Heckler nor Castle Rock v. Gonzalez has real relevance here. Castle Rock considered the deep-rooted nature of law enforcement discretion as a tool for interpreting a statute, not as a constitutional standing rule. And, as explained above, Heckler is not about standing and only states a presumptive rule. The court's remaining authorities are likewise consistent with the understanding that prosecution decisions are generally committed to an agency's absolute discretion, unless the relevant law rebuts the presumption. For example, TransUnion states that it is only when unharmed plaintiffs are before the court that Article 3 forecloses interference with the discretion of the executive branch. In sum, all of these authorities point, not to the majority's new rule, but to the same ordinary questions we ask in every case: whether the plaintiff has a concrete, traceable, and redressable injury. Despite the majority's capacious understanding of executive discretion, today's opinion assures the reader that the decision does not suggest that federal courts may never entertain cases involving the executive branch's alleged failure to make more arrests or bring more prosecutions, despite its otherwise broad language covering the exercise of enforcement discretion over whether to arrest or prosecute. The majority lists 5 categories of cases in which a court would, or at least might, have Article 3 jurisdiction to entertain a challenge to arrest or prosecution policies, but this list does nothing to allay concern about the court's new path. The court does not identify any characteristics that are shared by all these categories, and that distinguish them from cases in which it would not find standing. In addition, the court is unwilling to say that cases in 4 of these 5 categories are actually exempted from its general rule, and the one remaining category is exceedingly small. I will discuss these categories one by one. First, the majority distinguishes selective prosecution suits by a plaintiff to prevent his or her own prosecution. But such claims are ordinarily brought as defenses in ongoing prosecutions, as in the cases the court cites, and are rarely brought in standalone actions where a plaintiff must prove standing. This category is therefore little more than a footnote to the court's general rule. Second, the majority grants that the standing analysis might differ when Congress elevates de facto injuries to the status of legally cognizable injuries, and it hypothesizes a situation in which Congress, I, specifically authorizes suits against the executive branch by a defined set of plaintiffs who have suffered concrete harms from executive under-enforcement and, 2, specifically authorizes the judiciary to enter appropriate orders requiring additional arrests or prosecutions by the executive branch. It is puzzling why the presence or absence of such a statute should control the question of standing under the Constitution. We have said that the enactment of a statute may help us to determine in marginal cases whether an injury is sufficiently concrete and particularized to satisfy the first prong of our 3-part standing test. But once it is posited that a plaintiff has personally suffered a de facto injury, i.e., an injury in fact, it is hard to see what the presence or absence of a statute authorizing suit has a bearing on the question whether the court has Article 3 jurisdiction, as opposed to the question whether the plaintiff has a cause of action. In the end, however, none of this may matter because the majority suggests that such a statute might be unconstitutional. Third, the majority tells us that the standing outcome might change if the federal government wholly abandoned its statutory responsibilities, but that statement is both equivocal and vague. Under what circumstances might the court say that the federal government has wholly abandoned its enforcement duties? Suppose the federal government announced that it would obey 80% of the immigration laws or 70% of the environmental laws. Would the court say that it had wholly abandoned enforcement of these bodies of law? What would happen if the final memorandum in this case had directed DHS agents not to arrest anyone convicted of any covered crime other than murder? DHS would still be enforcing the arrest mandate as to one of the many covered crimes. Would this only murder policy qualify as complete abandonment? And why should the ability of a particular party to seek legal redress for an injury turn on the number of others harmed by the challenged enforcement policy? Standing is assessed plaintiff by plaintiff. The majority has no answers, and in the end, it cannot even bring itself to commit to this complete abandonment exception. It says only that the standing calculus might or arguably could change. Fourth, the court says that a plaintiff might have standing to challenge an executive branch's arrest or prosecution priorities and the executive branch's provision of legal benefits or legal status, because the challenged policy might implicate more than simply the executive's traditional enforcement discretion. Exactly what this means is not easy to ascertain. One possibility is that the majority is talking about a complaint that asserts separate claims based on the grant or denial of benefits, the grant or denial of legal status, and harms resulting from non-enforcement of a statutory mandate. In that event, standing with respect to each claim would have to be analyzed separately. Another possibility is that the Seth majority is referring to a claim asserting that non-enforcement of a statutory requirement requiring the arrest or prosecution of third parties resulted in the plaintiff's loss of benefits or legal status. Such a situation is not easy to imagine, and the majority cites no case that falls within this category. But if such a case were to arise, there is no reason why it should not be analyzed under our standard three-pronged test. Fifth, and finally, the majority states that policies governing the continued detention of non-citizens who have already been arrested arguably might raise a different standing question than arrest or prosecution policies. The majority provides no explanation for this non-committal distinction, and in any event, as the majority acknowledges, the states in this case challenged non-compliance with the detention mandate in addition to the arrest requirement. The court points to what it sees as a representation by the Solicitor General that the final memorandum does not affect continued detention of non-citizens already in federal custody. But as Justice Barrett notes, the government argued that when it chooses not to remove someone under the final memorandum's guidance, its mandatory detention obligation ends, meaning it is asserting discretion over continued detention. In any event, arrest policy cannot be divided from detention policy in this case. When a person is arrested, he or she is detained for at least some period of time, and under the detainer system involved here, arrest often simply means transferring an immigrant from state custody to federal custody. As best I can tell, the majority's distinction between arrest and detention is made solely to avoid the obvious inference that our decision last term in Biden v. Texas should have dismissed the case for lack of standing, without analyzing the government's detention obligations. In sum, with the exception of cases in the first, very small, category, civil cases involving selective prosecution claims, the majority does not identify any category of cases that it would definitely accept from its general rule. In addition, Category 2 conflates the question of constitutional standing with the question whether the plaintiff has a cause of action. Category 3 is hopelessly vague, Category 4 is incomprehensible, and Category 5 actually encompasses the case before us. The court declares that its decision upholds our constitutional system of separation of powers, but as I said at the outset, the decision actually damages that system by improperly inflating the power of the executive and cutting back the power of Congress and the authority of the judiciary, and it renders states already laboring under the effects of massive illegal immigration even more helpless. Our Constitution gives the President important powers, and the precise extent of some of them has long been the subject of contention, but it has been widely accepted that the President's power reaches its lowest ebb when he contravenes the express will of Congress. For what is at stake is the equilibrium established by our constitutional system. That is the situation here. To put the point simply, Congress enacted a law that requires the apprehension and detention of certain illegal aliens, whose release, it thought, would endanger public safety. The Secretary of DHS does not agree with that categorical requirement. He prefers a more flexible policy, and the court's answer today is that the executive's policy choice prevails unless Congress, by withholding funds, refusing to confirm presidential nominees, threatening impeachment and removal, etc., can win a test of strength. Relegating Congress to these disruptive measures radically alters the balance of power between Congress and the executive, as well as the allocation of authority between the Congress that enacts a law and a later Congress that must go to war with the executive if it wants that law to be enforced. What the majority has done is to apply Oliver Wendell Holmes's badman theory of the law to the separation of powers. Under Holmes's theory, as popularly understood, the law consists of those things that a bad man cannot get away with. Similarly, the majority's understanding of the executive power seems to be that a president can disobey statutory commands unless Congress, by flexing its muscles, forces capitulation. That is not the Constitution's conception of the executive power. The Constitution, instead, requires a president to take care that the laws be faithfully executed. Neither the Solicitor General nor the majority has cited any support for the proposition that a president has the power to disobey statutes that require him to take enforcement actions, and there is strong historical evidence to the contrary. The majority's conception of presidential authority smacks of the powers that English monarchs claimed prior to the Glorious Revolution of 1688, namely, the power to suspend the operation of existing statutes, and to grant dispensations from compliance with statutes. After James II was deposed, that changed. The English Bill of Rights of 1689 emphatically rejected the pretended power of suspending of laws or the execution of laws by regal authority without consent of Parliament, and the pretended power of dispensing with laws or the execution of laws by regal authority as it has been assumed and exercised of late. By the time of the American Revolution, British monarchs had long abandoned the power to resist laws enacted by Parliament, but the Declaration of Independence charged George III with exercising those powers with respect to colonial enactments. One of the leading charges against him was that he had forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained, and when so suspended, had utterly neglected to attend to them. By 1787, 6 state constitutions contained provisions prohibiting the suspension of laws, and at the Constitutional Convention, a proposal to grant the president suspending authority was unanimously defeated. Many scholars have concluded that the Take Care Clause was meant to repudiate that authority. See works of James Wilson, describing clause as providing that the president holds authority, not to make or alter or dispense with the laws, but to execute and act the laws. Early decisions are inconsistent with the understanding of executive power that appears to animate the majority. In 1806, Justice Patterson, while presiding over a criminal trial, rejected the argument that the president could authorize the defendant to violate the law. He concluded, "The President of the United States cannot control the statute, nor dispense with its execution, and still less can he authorize a person to do what the law forbids. If he could, it would render the execution of the laws dependent on his will and pleasure, which is a doctrine that has not been set up, and will not meet with any supporters in our government. In this particular, the law is paramount." In Kendall v. United States ex rel. Stokes, the full court rejected the president's claim that he had the authority to disregard a statutory duty to pay certain sums to a government contractor. Contend that the obligations imposed on the president to see the laws faithfully executed implies a power to forbid their execution, is a novel construction of the Constitution, and is entirely inadmissible. The court made the obvious connection to how the separation of powers, vesting in the president a dispensing power, would result in clothing the president with a power entirely to control the legislation of Congress, and paralyze the administration of justice. The original understanding of the scope of the executive's prosecutorial discretion was not briefed in this case, and I am reluctant to express a firm position on the question. But it is indisputable that we have been provided with no historical support for the position taken by the Solicitor General or the majority. This sweeping executive power endorsed by today's decision may at first be warmly received by champions of a strong presidential power, but if presidents can expand their powers as far as they can manage in a test of strength with Congress, presumably Congress can cut executive power as much as it can manage, by wielding the formidable weapons at its disposal. That is not what the Constitution envisions. I end with one final observation. The majority suggests that its decision rebuffs an effort to convince us to usurp the authority of the other branches, but that is not true. We exercise the power conferred by Article 3 of the Constitution, and we must be vigilant not to exceed the limits of our constitutional role. But when we have jurisdiction, we have a virtually unflagging obligation to exercise that authority. Because the majority shuns that duty, I must respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.